Hello, America. You are listening to Protecting Your Vote, the podcast. My name is J. Christian Adams. I'm the president of the Public Interest Legal Foundation, the nation's only nonprofit law firm dedicated exclusively to election integrity. Thank you very much for joining today in this new episode, Protecting Your Vote. Glad you're here. Lots happening since we last talked. Probably the biggest news that's happened since we last talked is a lawsuit by the United States Department of Justice, where I used to work in the voting section, against Georgia for passing election integrity legislation. And what this election integrity legislation did was very small. We'll cover that in this podcast, but lots more about the lawsuit. What I want to emphasize, and folks need to understand, is what Georgia is suffering from is an activated partisan voting section, an activated partisan Assistant Attorney General for Civil Rights, Kristen Clark, and at the end, an activist Department of Justice. But don't lose sight of the fact it starts low in the voting section, the Civil Rights Division, because these units of the Justice Department are filled with people who hate election integrity legislation. They think it is Jim Crow 2.0, which of course minimizes the violence, the evil of Jim Crow. Jim Crow was about billy clubs, German shepherds, fire hoses, police dog bites. It wasn't about what Georgia is doing, and to say otherwise is a lie. So let's get deep into this. What did Georgia do, first of all? Georgia passed a law that requires you simply to prove who you are when you vote by a mail ballot. In other words, when you go to Georgia and vote in person, you have to show voter ID. But when you do a mail ballot, an absentee ballot, the new law says that you simply write down on the form that you get to get an absentee ballot your voter number or some other form of identification. It's not just your voter number, which, by the way, you get your voter number for free from the county election office. So this is not some nefarious, holy grail that one has to search for. It's sent to you for free from the election office on your voter card. There's other ways you can prove your identity, but this is the easiest way to do it. And so this law was passed to make sure that people who cast mail ballots are really who they say they are. I can tell you from experience and litigation that I was involved in that, in fact, mail balloting is the biggest form of liability and fraud in our election system. Mail ballots are the problem. And the more mail ballots, the more absentee ballots we have, the more chance we have of lost mail ballots, people being disenfranchised, people not having their vote counted because of defects, and ultimately people not really casting the vote. Someone else is doing it, and that has happened a lot. So Georgia passed this law, and the Department of Justice filed a lawsuit under the Voting Rights Act. Now, I brought a lot of cases under the Voting Rights Act, and the theory behind the Georgia lawsuit is flawed from the start. Flawed from the start. What the Justice Department is saying, and this is important to understand, is that Georgia legislators passed this law specifically with racial motivated intent. In other words, they passed the law because they wanted to pass a law that affected black people negatively more than it would white people. Now, when you're done laughing, we can get into the heart of it. Under the Voting Rights Act, a state can violate the law two different ways. They can either pass a law with a racial intent, like we just talked about, or one that actually affects somebody negatively in the real world. That's called a results test. And under the Voting Rights Act, either one of those could give rise to a claim. But the Justice Department, curiously, only chose intent. And probably the reason they did that is because they could not prove results. Because we all know that writing your voter number down on a piece of paper does not have any actual real-world racial discriminatory results. So let's go to intent. Let's talk about, what do I mean by intent? Intent means state of mind. It means what you were thinking when you passed the law. Now, I have brought and won intent claims against election officials in the past. And what you do is a deep dive into their thinking when they pass the law. You're trying to prove that somebody was targeting blacks. That's what Georgia is alleged to be doing by the Justice Department. And you prove that with circumstantial evidence. There's a case called Arlington Heights, and it gives a whole bunch of criteria. I'll give you one test under Arlington Heights. If the legislature knew that a law would impact one racial group more than another. Here's another test. Deviation from normal procedures. What does that mean? It means that the legislature did things really differently when they passed this law versus what they normally do. All of that have been held by courts to be evidence of racial intent. The Justice Department will have to prove the case, and I think they might have a hard time doing it. Now, the Public Interest Legal Foundation was the first organization to intervene on behalf of Georgia to help defend the statute. And when you look at the documents we filed in court, you'll see a number of interesting things, that defenses, arguments that even Georgia didn't make. For example, we claim that the evidence relied on by the Justice Department in this case, if the court were to accept it, would render the Voting Rights Act unconstitutional. It would render the Voting Rights Act beyond the power of Congress to legislate to control states and their state election procedures. We also tear up some of the allegations, the evidentiary allegations, that these outlandish ones that are in the Justice Department complaint that have no relevance, such as, for example, Brian Kemp didn't have any African Americans at the press conference announcing the law's enactment. Oh, okay. Yeah, that's really evidence of racial intent. Lots of nonsense like that. And so in our complaint, in our answer to the complaint, I should say, the Public Interest Legal Foundation goes after these various arguments. Now, I will tell you that I was surprised that Georgia didn't make these same arguments. Georgia didn't allege unconstitutionality. In fact, I don't think any intervener defendant has. But that's very important because the federal government cannot go beyond the power of what the Voting Rights Act allows. And when you make the allegations that the Justice Department is making, those evidentiary, those facts would go beyond the power of the Voting Rights Act. Now, this lawsuit is not only an abuse of power, it's an attempt by the advocates, the left, to turn the Voting Rights Act into a one-way partisan ratchet. This is important to understand. The Voting Rights Act was a great leveler. It was an important piece of legislation. I brought Voting Rights Act cases in places like Georgetown, South Carolina, because no African Americans were being elected for local school board. And there was an at-large election, and it excluded black candidates, essentially. But when you use the Voting Rights Act to go after a tiny piece of election integrity legislation that barely requires anything to do, namely put a number down on an application that you're already filling out, then you have turned the Voting Rights Act into a partisan ratchet where you are asking courts to strike down laws because you think that it hurts Democrat voters. And make no mistake, that's what these plaintiffs think in these cases. They're worried about power, not civil rights. So Georgia enacted this law. Major League Baseball went to play in Colorado for the All-Star game, a state that has actually laws that make it harder to vote and make them more likely to be disenfranchised compared to Georgia. Hey, but that's okay. That's Major League Baseball and all their corporate sponsors. What the Peach State did was attempt to fix the problems of the 2020 election. But the Justice Department is abusing its power by seeking total control over every single election change in the country. What am I talking about? The Justice Department wants, and left-wing groups like the ACLU want, the Justice Department bureaucrats to have total control over state election laws. They want them to have the power to approve or reject every single election change. And it's in a bill called H.R. 4, which just got introduced this week. And they want the federal government bureaucrats in Washington, D.C. to have the power to decide whether or not a school district can move a polling place from a gym to a cafeteria, whether or not the office hours in Texas election offices can open at 8:30 or 8:35. Literally, if the Texas election office tried to change their hours from 8 to 8:35 under the plan in Congress called H.R. 4, Justice Department bureaucrats would have to agree to that change. They want to micromanage American elections. They want to abuse their power again, like they abused it in the past. Oh, what do you mean by abuse? What are you talking about abuse? Well, there's lots of stories there. Johnson v. Miller was Georgia redistricting when this power used to exist. The federal government before 2013 had the power in 16 states to accept or reject every single election change, redistricting, polling place locations, hours of operation, form of ballot, color of ballot, type of election, everything. They even had the right in Texas, or the power in Texas. They were reviewing resumes of individuals who were applying to be Spanish language translators. The Justice Department was approving or rejecting the hire of particular Texans as it related to them trying to become Spanish language interpreters for an election office. That's micromanagement. So what does the Justice Department do when it abuses power? It did things like it did in Johnson v. Miller with Georgia, where the Justice Department worked with outside groups. Oh, and by the way, this is a court that said this, not J. Christian Adams. The Justice Department worked with outside groups and essentially handed over power to outside groups like the ACLU. That's in the court opinion. That's not just speculation. It's in the court opinion, where the courts fined the DOJ hundreds of thousands of dollars for abuse of this power. There's more. Let's look at the town of Kinston, North Carolina. Kinston, North Carolina, small town in North Carolina's eastern side, had partisan town council elections, meaning you run as a Democrat or Republican. The voters approved in Kinston, which, by the way, is majority black. The voters approved a change to nonpartisan town elections. Because that's a change, where did it have to go? It had to go to the Justice Department for approval. And the Justice Department objected, blocked, canceled the change of not allowing the word Democrat next to a voter, because they feared if you took away the partisan hint that black voters wouldn't be able to win elections. That was in the objection letter by Loretta King, who was the acting assistant attorney general at the DOJ. We could go on and on with more instances of abuse of power. The power they want also extends to annexations. In other words, if a town wants to annex somebody, a lot, let's say, with two people who live on it, that annexation has to be approved by the Justice Department under H.R. 4 and what they used to do a long time ago. And the Justice Department could object to the annexation because, let's say, there's not enough black people being annexed, and these are white people being annexed, and two people added to a town will affect black voters. Well, what I'm describing to you is not made up. It is an objection that was lodged in the town of North South Carolina, a case in the year 2000s. So these are genuine, real, historic abuses of power, not just theoretical ones. That's what we're facing with H.R. 1. That's why the Public Interest Legal Foundation is suing as interveners to defend Georgia in their power and their right under the Constitution to manage their own affairs. I'm J. Christian Adams. Thank you so much for tuning in to Protecting Your Vote. We'll be back again soon with another podcast. If you'd like more information about this, you can find us at publicinterestlegal.org, and that's publicinterestlegal.org. Thank you very much.